Good morning, Ms. Mellon.
Doe versus Chair of the Parole Board, SJC-10239.
Good morning, Ms. Eisenberg. I understand that Council have worked with the clerk to modify the speaking schedules, for which I'm most appreciative, and I understand that you have 10 minutes.
Thank you very much. Good morning, Madam Chief Justice and Honorable Justices Beth Eisenberg and Patricia Guerin for the plaintiffs. We'd like to make three essential points for the court this morning. Number one, the individual liberty rights affected by operation of Section 133D and a half are fundamental, and the government's countervailing interest is neither compelling nor even rational.
How can we say that? I mean, the parole board can impose these conditions, had imposed these conditions beforehand. These are conditions of release on parole. I mean, how can you say that they're fundamental?
They're not the conditions of parole that were imposed on these parolees pursuant to their permit.
But they could have been. It could have been without a hearing. They could have been.
No, I respectfully disagree. They could have been conditions that were imposed pursuant to the hearing on whether or not to grant these prisoners parole.
Well, is the parole hearing a hearing in which conditions are negotiated? Or isn't it just a hearing as to whether or not they should be released on parole? Then the board sets whatever conditions they deem appropriate?
Indeed, but what happens is that there is a hearing to determine the individual's eligibility, and during that eligibility hearing, if in fact there is a statute like this where there's an operative irrebuttable presumption,
just a condition, a mandatory condition. I don't know why you're calling it an irrebuttable presumption, a mandatory condition.
Well, if it's a mandatory, if it's a condition, then it seems to me that it needs to, in order for it to be, if it infringes on a liberty right, we say it's a fundamental liberty right, but even if this court were to find that it were less than that, there still has to be a nexus between what the government's interest is in imposing that particular condition.
And isn't there? Keeping people on parole away from their victims and monitoring their conduct, their whereabouts to ensure that they comply with that.
We say that the bracelet, or the shackle really, does far more than that. We say that what it does, in fact, is far beyond the constraints of simply assisting the parole board through the instrumentality of the Commissioner of Probation.
Would your clients prefer to be back in custody to wearing the GPS system?
No, I think these clients have been out on parole for so long and have done so beautifully.
But could I just ask? But their liberty is only conditional. They could be spending the time behind bars. They've been convicted. They've been sentenced. This is, as you will, a grace that they're given that they're not in custody anymore.
I would suggest to the court that under Morrissey versus Brewer, at this point, given their performance on parole, their interest, as the Supreme Court said in Morrissey, is a fundamental liberty right that's valuable.
I just want to be clear. These named plaintiffs
Yes.
have been on parole, I think, since the 90s.
Yes.
But are you, what I'm trying to figure out, because the Commonwealth says this is a facial attack, it's not as applied to them, and I'm just trying to figure out which is it?
It is not. It is both facial and it is as applied. We've made that clear in our brief at page 22 when we have a due process discussion. We say very clearly, as applied to these plaintiffs, and indeed as applied to all parolees, the statute is irrational.
But you acknowledge that it makes a difference, these plaintiffs versus somebody who may be coming up for parole right now.
We do. What we think is that it's particularly important when you're talking about the retroactive application of the statute to these particular plaintiffs. So we make the claim that because they cannot be heard, those aspects of their performance that would be germane to the parole board elsewise cannot be aired before the parole board in an effort to impose conditions that are consistent with their presentation and public safety.
The other factual question, or sort of how parole works question I had was, under, you're going to correct me on the statute, but I think it's just Section 133 by itself. There's language about the parole board can modify, amend, alter conditions of parole at any time.
Yes, that's true.
As a practical, how does that work? I mean, put this statute aside, how does that work in regular parole cases? Is
Well,
there a hearing, or is there just a pronouncement that this is the way that it's going to be?
It can be one or the other. It can be a hearing, or it can be without the benefit of a hearing. But it seems to me that at bottom, if there are modifications of those conditions, there has to be some event that triggers it. Now, it may be that there's something short of conduct or an incident that would warrant revocation, so that the terms and conditions of parole can be tweaked to better effectuate the rehabilitative effects of parole and to better effectuate the board's ability to supervise in public safety. But here, because of the nature of this infringement, what we say is that this infringement is not like other infringements. We say that it doesn't matter that they're parolees because, as I mentioned earlier in Morrissey versus Brewer, the Supreme Court held that parolees enjoy a fundamental liberty which is valuable. And freedom from physical restraint of the ankle shackle and GPS monitoring is fundamental. As the Supreme Court said in Youngberg versus Romeo, they recognized that Romeo was developmentally disabled and was restrained by shackles placed on his arms for portions of each day. And the Supreme Court held that Romeo's freedom from bodily restraint was quite literally freedom not to be physically strapped to a bed. In guardianship of Roe,
What if the technology was you simply had to carry a cell phone around? You didn't need the ankle bracelet, just the cell phone. Would that also be physical restraint, or is it the actual application of the?
By the statutory terms, it says wear, and we.
The wearing is physical restraint.
The wearing is part of the statutory terms, and we think that's significant because we think that what that signifies is not simply the way in which this technology is applied. You can't wear it in something that you take off because the whole thrust of the statute is.
What if it could be implanted, a little chip?
Then I think we'd have a different discussion than we're going to have today about corporal punishment, perhaps, or we'd have a different discussion than I would hope to have today with the court about stigma. But we'd still be having the same discussion about restraint of liberty, because restraint of liberty.
But they can go anywhere except where they couldn't otherwise go.
They
In other words,
cannot.
the parole board can absolutely say you cannot go into these areas because that's where the victim lives. That can be a condition.
Yes.
So is that physical restraint?
It is, but the physical restraint that is most worrisome here is the restraint that results from the psychological effects of having one's bodily integrity and autonomy and dignity affected by the ongoing wearing of apparatus, so that beyond the legitimate nexus between supervising someone outside of an exclusion zone, and by the way, these people two of them don't have exclusion zones, and two have exclusion zones that would have been held unconstitutional under Pike. But what we say, and what the trial court had a kind of constitutional scotoma about, as does the government, we say, is that what's at issue here, the restraint here, is the physical sense of being outed, of being marked, of being distinguished, of being set apart from the rest of society. And we know that this is true because not only were the affidavits uncontroverted below, but we know from the record that's been presented to you and by the truly wonderful amicus brief by the Massachusetts chapter of ATSA that more than 2/3 of the states in this country are using GPS monitoring for sex offenders.
But they could be set apart from society by being in custody.
Yes,
They could be.
They could, but there would have to be a reason for that.
No,
to be.
if they could be not released. They could, I mean, parole has been defined in our cases in a different way.
They could be held in custody. It's truly better to be out in the world.
Well,
than to
your
be in
argument
custody.
is that they're afraid of they're being segregated from the rest of society.
Yes.
But they could be segregated physically by being
But
in
there
one
would
of our
have to be a
institutions.
reason.
But
There would
these
have to be
plaintiffs
a
are already
reason.
out.
But when you make the facial challenge,
Well, the facial challenge is because there's no way to know in the universe of people who are eligible for parole. I mean, the parole board has historically been given a lot of, is that 13 seconds
Yeah.
that I have?
Keep
Oh.
talking.
The parole board has been given, I had a freak out moment. The parole board's been given historically a lot of deference to look at the candidate and decide what's necessary and what's not necessary to balance.
well, isn't it better for the candidate, for the parole board to consider, well, this person, generally a he would be a candidate for parole provided we can put him on a GPS system rather than just say, nope, he's not a candidate for parole, period. It's a condition of monitoring that improves someone's chances of being released.
But the
And it's
board-
better to have the slight infringement of their physical freedom that might separate them from the rest of society than total segregation from society.
But we say, if that is true, then what is the harm for the board to use its ordinary powers to discriminate between those people that they're looking at who may need the application of this technology and who don't? It's expensive. It malfunctions.
The legislature, in its wisdom, passed a statute that applies to all sex offenders.
Ms.
Well-
Heisen, so you may respond to Justice Cowan.
Well, I think that whether or not that is so depends on whether or not this court decides whether this is a due process problem or whether this is a punitive problem, whether this is regulatory or punitive. If it's punitive, then the legislature, as you say, has imposed these conditions, and the due process and substantive due process discussion that I started with this morning doesn't really have an application to that. If it's regulatory, then it does, because there has to be a compelling reason for this kind of
Ms.
imposition.
Eisenberg, could I ask you a quick question on your relief?
Please.
Relief.
Yes,
As I understand it, you sought a preliminary injunction.
yes.
And as I read your brief, it's a little unclear because the issue presented is not consistent with your closing paragraph. Are you asking that we send this back for a further hearing? Or are you asking, in other words, your relief says the plaintiffs met their burden of entitlement to injunctive relief. Are you talking about preliminary injunctive, permanent injunctive, and what are you asking us to do on the declaratory judgment piece?
Well,
A quick answer, if you can.
we think that we're asking the court to reverse the trial court's order on the denial of the preliminary injunction. We're asking the court to find, based on the law, that we would be entitled to a permanent injunction. And we're asking the court then further to declare what the law would be. In essence, this would resolve the case, as we think it did when we presented these issues before. The only, value to going back down is if this court has questions about the record itself and whether further development of the record would have some bearing on its analysis of the legal issues.
Thank you.
Thank you very much.
Mr. Katz, good morning.
Morning, Your Honor. May it please the Court, Assistant Attorney General Scott Katz on behalf of the defendants. Before addressing the merits, I want to briefly emphasize three key points that I think really help provide the context in which the Court needs to evaluate the plaintiff's claims. First, the plaintiffs are on parole, a status that this Court has described as a variation on imprisonment. Second, the statute at issue in this case applies to these plaintiffs only because they're subject to that variation on imprisonment and applies to them only for the duration of their criminal sentences. And third, much of what the GPS law now requires was already being done before the statute took effect.
Well, as to level 3.
Well, it was only being done as to level 3 as a, across the board, but the parole board was using, in its discretion, was applying GPS to some level 2.
As an individualized determination, correct?
Correct, but they were not holding hearings on that issue. It was when, and including in one of the plaintiffs in this case, when in the judgment on recommendation from a parole officer, the parole board deemed that GPS would be appropriate, they would do that.
You mean after parole had begun?
Correct.
Is there technology out there that consists of a less intrusive device?
I mean, I think the technology is improving all the time. I mean,
But is there one out there now?
I'm
Obvious.
I'm not sure one way or the other, Your Honor.
I have to say the affidavits are pretty horrifying.
I was going to ask Mr. Katz, are there any, I didn't see any in your brief, are there any facts that are in those affidavits that you contest?
Well, I mean, I wouldn't say that we contest them. I mean,
You haven't, the board has not contested them, correct?
Correct. I mean, we're here on an appeal from a
No,
preliminary injunction.
I understand. I just wanted to know factually, the board has not contested the facts.
Not for purposes of a preliminary injunction. I mean, surely as this case goes forward, we would want to develop the record to find out what, essentially a more complete picture of what the effects of GPS monitoring are on these plaintiffs. I mean, this case was filed.
Did you ask for that relief?
I'm sorry?
Did you ask for that relief? Was that the basis of the preliminary, your opposition to the preliminary injunction?
No, but again, my point is just that I agree that we accept those facts for purposes of this appeal on the denial of the preliminary injunction. But as the case goes,
if the board has not, as a general matter, if you don't draw to a court's attention at the time that you are opposing a motion, we can take the facts as established. And if the party
I'm not
opposing
contesting
it,
that for purposes of this appeal from the
I'm just
preliminary
testing
injunction.
that for purposes of, if you don't put in counter affidavits, as a general matter, the court can issue orders that are consistent with whatever claims have been taken.
I'm not disagreeing with that, Your Honor. My point is limited to the fact that if this case goes forward, we're going to take discovery from the plaintiffs to see. I mean, this case was filed just months after the statute became effective. It's, nearly 2 years later now. I mean, we would obviously, as the case goes forward, take additional. When you're talking about a permanent injunction, we would take additional discovery to determine what the actual effects on these plaintiffs have been in the interim.
Has the board moved for discovery?
No, I mean, the status of this case is this case was, we haven't even filed an answer in the case yet, Your Honor. I mean, the only thing that's happened in the case was the complaint was filed, motion for a preliminary injunction, our opposition, a non-evidentiary hearing, and then this appeal. So when this case goes back, we would file an answer, or depending on the outcome here, perhaps a motion to dismiss, and then go from there. Turning to the merits, I'd like to start with the plaintiff's substantive due process claims. Our position is that the statute here does not infringe on any fundamental rights, and as a result, it's subject to only rational basis review, meaning the statute need only bear a reasonable relationship to a permissible legislative objective. And in this case, in our brief, we've identified at least 3 permissible legislative objectives, which
Is it that it doesn't infringe on any fundamental rights of parolees or any fundamental rights of citizens?
Well, I mean, I think the question is, as Your Honor implies, I mean, it's how you frame the fundamental right. And here, where the statute applies only to parolees, I think that in asking whether a fundamental right exists, the proper inquiry is, does a person who is on parole have a fundamental right to be free from monitoring, to be free to enter the types of zones that are designated as exclusion zones?
Does it change your analysis if you are talking about these named plaintiffs who have been apparently successfully on parole for 15 or so years?
No. I mean,
Because?
Well, because the legislature is entitled to make I don't think it's irrational for the legislature still, despite the length of time that has passed, to still want to keep an offender away from his or her victim.
But I guess I'm really going to the sort of 2008 Doe analysis about the reasonableness and fairness of applying the statute retroactively.
Well, a few points. I mean, first, I would just note in passing that that argument was not presented to the motion judge. was not made, the plaintiffs did not make that argument in their brief to this court.
Yes, they did.
Well, I don't think they made any argument that because this statute fails to satisfy the retroactivity analysis that, I mean, they cited the case, admittedly, but they didn't present any developed argument that using the 3 factors that this court looked at in that Doe case, that this statute fails to satisfy that analysis.
I'm sorry, please finish.
I was going to respond on the merits. I mean, in any event, I think even under that balance, the statute satisfies that standard because of the still unquestionable public interest that it served. I mean, it's not just about, this statute is not just about protection of the public. I mean, the essence of parole is supervision. And the legislature could rationally determine that using GPS is just a more efficient, more effective means of allowing parole officers to supervise individuals who are under their charge. And the fact that the legislature has chosen to use the offense of conviction, I mean, if they don't want to do it across the board for every person on parole, and they want to do it by the offense of conviction for a class of persons that is generally acknowledged to have a higher level of recidivism.
Well, that was the same in Doe, right? I mean, he was convicted of a rape, and it was classified as a violent offense.
Well, that's true. I mean, there are a few significant differences between here and in that case. First of all, this requirement only applies for the duration of the parole. In Doe, the problem there was that individual was going to be subject to lifetime registration and could never be relieved.
That wasn't I mean, that was a
well,
problem.
that was one of the, I would suggest, major problems in the case. Another point is that in
Can I ask you a question
Sure.
just on that point, Mr. Katz? I understand the state's powerful interest in supervising people who are likely to repeat their offense. Don't we have in these plaintiffs people that the Sex Offender Legislative Board, which is the agency that is charged with assessing essentially the likelihood of repetitiveness, have required that at least one person not register at all and the other is a level 1 offender?
well, let me disagree with 2 premises in your question.
But I don't think I have premises.
Well, one of the individuals, the individual who's not required to register,
Right.
is in fact not on parole subject to this statute. The other point I would make is that there are reasons to want to supervise individuals other than just their likelihood of committing the same types of offenses. I mean, the legislature or the parole board could decide, for example, that, well, individuals convicted of drug distribution offenses, we want to keep those people away from schools, away from playgrounds, and could then say that we're going to put those people on GPS and create those as exclusion zones, just to, not even because that's the type of offense that makes someone likely to recidivate, but because we want to ensure that as part of this person's rehabilitation, that they're able to comply with that kind of condition.
Sounds more like as part of this person's punishment, we're not going to have them go there, doesn't it?
I don't think so, Your Honor. I mean, I think it's a process of reintegrating the person into society and making sure that they're able to comply with conditions that are placed upon them. And one of the ways to test that, this is a way for the parole board to ensure that they are complying with those conditions.
I take it, Mr. Katz, that you would agree that one way that the monitors assess whether or not they are out of the exclusionary zones is being able to know where they are at every minute of the day and night, correct?
I'm sorry?
In order to know whether or not a parolee has entered an excluded zone, whoever is monitoring has the capacity to know where that person is 24/7, 365, correct?
That's correct, but I mean, that's the nature of parole. The parole board would be entitled to have that information regardless of whether or not they were using it by GPS. I mean, a parole officer would be entitled to visit a parolee at his home, contact him at his workplace. They're entitled to know, because someone is on parole, the parole board is entitled to know where they are and what they're up to. And GPS is really just a means of more efficiently and more effectively accomplishing that task.
Thank you, Mr. Katz.
Thank you.